Hey everyone, welcome back to the channel. Today we're diving into a follow-up on a case I've been tracking involving a so-called sovereign citizen from Lake Forest Park. This individual has been making a name for themselves in court, literally walking out in the middle of hearings, and yet somehow hasn't faced serious consequences like contempt charges. It's wild, and we've got plenty of footage to show you. If you haven't seen the earlier videos covering this person's courtroom antics, I've included a link at the top so you can catch up. Trust me, it's a lot to unpack, and you'll want the full context before diving into today's video. Also, a lot of viewers have been asking about parts 3 and 4 of the series on the sovereign citizen Karen, who sued me and lost. Those videos are coming. I've just been traveling recently and didn't want to rush them, but now I'm home for a full week before heading to Dublin, so you can expect those next parts to drop before I leave. Alright, with all that out of the way, let's jump straight into today's episode and witness the next level of courtroom chaos.
Well, Mr. Schuster, just to give Your Honor a little bit of background on this one, Mr. Schuster is representing himself. The court has previously gone through the waiver of right to counsel. When we were here, I believe the last hearing, Mr. Schuster gave an indication that he wanted to resolve these matters. So I have drafted a plea form with the city's offer on it. I just am not sure how to get it to him. I can certainly send it to him in the chat. I just don't know if he has the ability to download that and sign it if in that respect. So,
hi, ma'am. How are you today?
Hold on a second. So let's preliminary matter. This is Jonathan Schuster, 4A0525748. So it sounds like Ms. McDonald's trying to get you some documents, Mr. Schuster.
Yeah, so for the record, I reserve all rights and retain them. I am making a special visitation for the matters pertaining to Jonathan Schuster, for I am the beneficiary. I had mailed out some paperwork over to the prosecution as well as submitted it to the court. Have you received those, ma'am?
So I've received 2 motions from Mr. Schuster. Have you?
Yeah, the 2 motions as well as the affidavit, as well as the certified copy of the. So you got that paperwork? Were you able to read it?
I have 2 motions. One was, both were received today.
Right. You should have received an affidavit as well.
I don't see any affidavits.
It's on the back.
The affidavit was received at the same time that the motions were submitted, and so.
and I don't know that we've received anything. I'm checking with my office right now, but I don't see anything in our files.
I emailed to Ms. McDonald this morning.
You did? I'm sorry, what, Madam Clerk?
I emailed to you a copy of the first motion to dismiss and the affidavit of truth, it's called.
Yep, there was a motion for dismissal as well as a motion for show cause, as well as the affidavits.
Hold on, Mr. Schuster. Hold on, Mr.
And
Schuster.
so those were sent over
Hold on, Mr. Schuster.
as well as submitted to the court.
Mr. Schuster, hold on a second. Ms. McDonald's getting caught up. I do have your affidavit.
I just wanted to.
But by now, one thing should be clear. When you're acting like an adult, it's really important to let someone finish speaking before jumping in. Interrupting not only comes off as disrespectful, but it also unintentionally highlights a serious lack of awareness.
The office email, because I don't have anything from you today. Except the orders from Mr. Bailey Garrison. And the borrow out information from Mr. Goodwin.
Okay, if you need time to get that, that's fine. I just require that due process is, that we.
Okay, hold on, Mr. Schuster. There's going to be plenty of time for you to talk.
Yes. Thank you. Also, the prosecution, I've never received anything from you as well, but there is an email on for contact information, so you can send that over via email if you have anything to send to me.
We sent you discovery at both addresses that you gave to the court. So they were physical copies because there's digital evidence as well.
Well, I just have never received anything from you.
Well, it went out to your mail. So I don't know what to tell you about that.
Did you check,
Yeah.
Mr. Schuster?
I mean, I haven't received anything.
That's not my question. My question is, are you checking your mail regularly?
Oh, I definitely look out for mail regularly.
Okay, and does the court have your current address?
So he updated it, Your Honor. We actually had this situation issue a couple of weeks ago, or actually almost a month ago, where we had sent out full discovery to the defendant, and then he indicated that that wasn't his address. So we sent out another packet of full discovery to him to the address that he updated. Let's see, the one on Kenyon Street.
2318 California Avenue.
You gave us on January 27, 600 Southwest Kenyon Street, apartment G201 in Seattle.
You're talking about on January 27th when the judge denied subject matter jurisdiction that day?
So the address that you gave to the court on January 27th was the 600 Southwest Kenyon Street, apartment G201. So
the same day that
that was the
Mr. Schuster,
denied subject matter jurisdiction?
Mr. Schuster, is that the address you gave on January 27th?
I don't recall, but I do have, somewhere she can send it to. So
Well,
that
we're not going to play the game of you updating your address every court date so that you can avoid service of discovery.
I'm just letting you know that I didn't receive it, and I don't recall, so I'm giving you an address, but
You recognize that address?
which address?
Can you read that one more time, Ms. McDonald?
Yes, the address on January 27th that he requested discovery go out to was 600 Southwest Kenyon Street, apartment G201 in Seattle. The one prior to that he requested was 1005 North Cleveland Street, apartment C in Kennewick, Washington. All discovery was sent to both of those addresses.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so the matter should have been dismissed anyways.
So the judge denied your motion to dismiss for lack of subject matter jurisdiction. The court found that there is subject
She did.
matter.
It was on the record. She denied subject matter jurisdiction.
Hold on, there's no regardless here. A previous judge has already reviewed your motions on subject matter jurisdiction and denied them. While the current judge isn't required to revisit those same motions, she sees no issue in formally denying them again.
Is that correct, ma'am?
I did. Did Ms. McDonald? Have you gotten that yet?
I just
Perfect.
So,
Have you had a chance to read over that, Miss?
So obviously Ms. McDonald has not had a chance to read over it.
Oh, I was referring to you, ma'am.
Okay, Mr. Schuster, let me talk. So do you remember doing the waiver of counsel on December 16th, where you said you wanted to go forward representing yourself?
Well, from the very beginning of this
Remember
matter,
signing this piece of paper saying you were representing yourself?
from the beginning.
That's not my question, Mr. Schuster.
Well, I'm answering your question. I would like.
I don't want a narrative. Yes or no?
Thank
Do you
you.
remember signing this piece of paper?
I don't recall.
Okay.
I don't know what paper you're showing me.
You're on this piece of paper.
I'm not sure what paper you're showing me because
Okay.
it's very far from the camera and
So,
it's
Mr.
just
Schuster-
very hard to read because it's blurry
Okay.
from this
So
angle.
let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form, you requested the court to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you're expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. These motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules. Nonetheless,
Well, this isn't the trial, so.
I am going to let you know that I have reviewed these motions. And if it's okay with you, Ms. McDonald, I'm going to go ahead and let Mr. Schuster know that I've reviewed these motions. There's two of them, a motion to dismiss for lack of subject matter jurisdiction, and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park Municipal Court is authorized to hear misdemeanor and gross misdemeanor cases along with violations of local ordinances. We are not authorized to hear federal matters. Your assertion that we are not authorized to hear federal matters is absolutely correct. Nonetheless, these are not federal matters. Federal courts do not have exclusive jurisdiction over travel and driving offenses. Proceeding with this case is not a due process violation of the Washington or the federal Constitution, and so I'm going to deny your motion to dismiss for lack of subject matter jurisdiction. Turning to your motion for show cause, you cite an RCW that outlines district court jurisdiction, which is not even applicable in this case, but nonetheless, Lake Forest Park Municipal Court is the correct venue for misdemeanor and gross misdemeanor driving offenses that occur in Lake Forest Park, Washington. The constitutional right to travel is not abridged by states and municipalities' adoption of regulations concerning driving privileges, and therefore I'm going to deny your motion for show cause against the prosecution. I'm also denying your motion to dismiss in that motion, finding that this court, again, does have subject jurisdiction.
Can you imagine being so certain that your motion is constitutionally sound, only to have a judge dismiss it so thoroughly that it's treated as if the prosecution didn't even appear? That kind of ruling really puts into perspective just how deep into legal trouble some self-proclaimed sovereign citizens dig themselves.
Address for Ms. McDonald to send discovery to. So at this point,
It was never a third. In the beginning, you had the correct address. It's no longer the correct address.
then it's
And
not the
so-
correct address. If it's no longer correct, then it's not correct. You've given a
Well, as of
address.
recent, as of literally not that long ago.
So when
so-
did the Kenyon Street address become a bad address?
I want to say within the last month-ish.
So sometime after January 27th, the Kenyon Street address became a bad address, correct?
And you said the motion to show cause was denied on what grounds?
It's not been properly filed. You did not comply with the court rules, but even allowing you to file and reviewing it, there's no basis for me to grant it. It is not legally sufficient to grant your motion.
To prove that you have subject matter jurisdiction?
So first of all, the prosecutor doesn't have to prove that the court has subject matter jurisdiction. I am ruling and telling you that this court does have subject matter jurisdiction for the reasons I previously stated.
I can
And
tell
this
the
is a
court.
court of record, correct?
Is a court of record.
You said this is a court of record?
It certainly is a court of record.
Ah, I see.
We are on the record now. So that being said, it sounds like Ms. McDonald has a plea offer to send you if you want to entertain that. Would you like her to send you that plea offer? And if so, what is the best way for her to do that?
Well, she's allowed to send me whatever she would like, but I do have an address since I want to make sure that, everybody has the correct information.
What is your current correct address?
The mailing address would be 2318 California Avenue. I believe that's Southwest. D?
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that's Seattle, Washington, 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family.
What was that?
Family. Hmm. And so, just so I'm clear, um, you're saying that the right to travel and privacy is not a federal matter, and that
I'm
you're
saying
saying that
that
you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington, and that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty, and a right because
No, this doesn't apply to a simple municipal driving case. The right for a state to govern itself comes from the 10th Amendment of the Constitution. Yet some self-styled travelers like to quote phrases about life, liberty, or property as if it's a magic loophole that lets them ignore the law.
And that the fact that there are federal rights around travel does not preclude Lake Forest Park Municipal Court from enforcing state and local ordinances. So what do you want to do on your case today, Mr. Schuster? Is it your intention to go to trial next week? Is it your intention to entertain a plea offer from Ms. McDonald?
Well, I just want the court to know that any judgment issued without proper subject matter jurisdiction is void and may be challenged at any time.
And you're free to
This
appeal
court
any ruling from
lacks
this
the
court.
authority to hear this case, and proceeding further would result in an unenforceable judgment. Therefore, this court must be dismissed.
You are free to appeal any ruling this court makes. You can certainly, since you
Almost definitely.
how to do that. Nonetheless, we have to figure out what you're doing today on your case. It's your readiness hearing, where you tell us if you want to go to trial next week or if you want to entertain a plea offer from Ms. McDonald.
Well, as I've stated, this case should be moved to the proper courtroom, which it's not.
In the proper courtroom, and that's not happening. And Mr.
If it's not transferred, I do. It should be dismissed.
I'm
And
not entertaining further motions to dismiss. Ms. McDonald, go ahead.
Yes, and Mr. Schuster, I sent to you in the chat because that is the only way for me to get that to you right now.
Oh no, you have my email. You got the information on the motions there. So you have the email listed above. I don't really know how to use Zoom like that, and so sending anything over through chat like this is just it's difficult. So email would be the best way if you want to get that to me faster. But of course, you have an address now that I'd be able to get the mail that you're saying you've sent already, but no worries. So
I'm using Zoom the same way we used it at the last hearing when we sent you documents and you were able to chat back and forth with me. So it's in that chat.
We didn't have a back and forth.
We did.
Chat. No, we didn't.
So there is a document in the chat for you to open and take a look at, and that is the city's plea offer. We are agreeing to dismiss 2 charges for a plea to 1 with a credit for time served recommendation. So if you'd like
as I've stated, you can email it so that I can properly see it, because that's the best way for me to do it quickly, because I don't really know how to use this chat function in Zoom.
Ms. McDonald, do you have the ability to email it to him?
I'm looking for the email.
Yep, it's at the top for the motion to show cause, as well as the bottom of the motion for dismissal. But I can also just read it to you if you'd like that.
If you can put that into the chat so I can make sure that I don't spell it wrong, that would be great.
Well, as I've told you, I don't know how to use the chat.
All right, so we're streaming live to YouTube, Mr. Schuster. Would you like to read your email for anyone who's watching YouTube to listen to and hear?
I mean, they can email me. I don't mind.
Then
yeah.
Spell out your email for Ms. McDonald.
Do you know how to spell my last name, Ms. McDonald?
Please just spell it out. Let's just be as clear as possible.
Well, it'd be my last name .jon@icloud.com.
Can you spell your last name for her?
Yeah. Are you ready, Miss McDonald?
Yes, I am.
Okay. SCH.
All right. If you'd stop treating the court like a game and provide a single address for all your paperwork, you might actually receive the discovery you need to properly defend your case.
Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now.
Right?
And so my
go
email, I'm using the same.
Camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on?
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
Okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
If you get disconnected, you know how to get back on it.
Okay. One moment.
Can you mute yourself, Mr. Schuster, and turn your camera off to read your email?
Oh, I saw that Carmen had sent something over.
Yes, you need to open it and reboot it.
Oh, it says what you had said on the record, correct?
No, it's an entire form. It's about, see how many pages that is? About 8 pages.
Can you mute yourself and take yourself off video while you review that, Mr. Schuster?
I think so. Let me see if I can do this correctly. Oh, so I see everything that you've sent over. Obviously, I'd probably have to look at it longer to make sure I
asking you
carefully.
I'm asking you to do that now. We're going to go back on the record.
Oh, okay. It just might take some time. I've gotten through some of it, but for me to understand what's going on, I definitely would have to read it. I don't know if you have enough time for all of that, but if you do, I don't mind. Taking the time to fully get into it.
Ms. McDonald, you're on mute.
If he's asking for more time to go over the city's offer and to consider that, I don't have an objection to continuing the matter if he agrees to waive speedy trial.
Oh no.
Well, if you don't wish to waive speedy trial, then
Well, if she doesn't want to give me more time, then I guess we just got to.
The problem is, Mr. Schuster, you have to be brought to trial within 90 days of your arraignment date. And so your trial is scheduled for next week, but if you want to take advantage of the city's
on
offer,
the 11th.
Right. If you want to take advantage of
9 a.m.
If you want to take advantage of the city's offer and you want more time to review it, unfortunately, you would need to set over that trial date.
Well, I can counter to you right now if you'd like.
I'm happy to go in a breakout room.
I don't know what that means.
I don't know that these are necessarily conversations to have on the record, but
if you want to go into a breakout room, in other words, go into a separate Zoom room with just Ms. McDonald so you can discuss her offer, I'm happy to allow you to do that right now.
Okay, how does that work? How do we do that on Zoom?
I can do that. I can put you in a breakout room. You'll get an invitation.
Do I need it? Okay.
Pop up on your screen for you to accept.
Okay, so just wait until something pops up.
Yep, I'm going to put you in there right now. It will be into room 1.
How would I come back though?
There will be a button on the bottom right that says leave breakout room and back to main session.
Okay, so it says join breakout room. Prosecutor McDonald is inviting you to join room 1. So I just click join.
Prosecutor in the city had to step into a breakout room for a private discussion. And would it surprise anyone that when they returned, the prosecutor concluded that a competency hearing was necessary?